gun policy was absent from the first Republican primary debate, plus Professor Dru Stevenson on why he asked the Supreme Court to overturn its Second Amendment precedents and where he thinks the justices will actually come down. That and more on this episode of the Weekly Reload Podcast.
No, the devil's got no hold on me.
All right, ladies and gentlemen, welcome to another episode of the Weekly Reload Podcast. I'm your host, Stephen Gutowski. I'm also the founder of thereload.com, where you can head over and sign up for our free newsletter if you want to keep up to date with what's going on with guns in America. We just send you one email a week that gives you all the best news on the subject. And of course, if you want even more information and analysis, you can buy a membership as well, and you'll get a second email. We try not to overload your inbox, but we try to bring you all the most important pieces of news that we can in the week. This week, we have the new briefs in the latest Supreme Court gun case, United States v. Rahimi. And so I wanted to bring on somebody who can speak directly to that case, who's actually now involved as one of the amici in the case, filed a brief. We have Professor Dru Stevenson of the South Texas College of Law with us. Welcome to the show, Dru. How are you doing?
Good. Thank you for having me.
Yes, I appreciate you coming on. We had author and lawyer Mark Smith on a couple weeks back to discuss this case and give his point of view. He's a very pro-Second Amendment author and analyst, and we got his take. Now, I figured it's time for somebody from a different point of view, and who better than somebody who's actually filed a brief in the case. So can you tell us just a little bit about that brief itself? What are you and your colleagues arguing to the Supreme Court here?
So the brief makes three main arguments. And by the way, I should say up front, I was not the primary writer of the brief. Three law professors joined it together, and all of us contributed some small part. So,
and I believe there's a gun control group involved as well.
There is, and they kind of took the lead on it and had some appellate lawyers who drafted the brief. It did the primary drafting.
But so what is the
main argument, kind of three or four pronged argument, is first that the government has a responsibility to protect, not just ensure rights and personal autonomy and freedom, but also to protect people's safety and security from each other. And that means that there has to be some regulation of violence and the means of violence because of how common shootings are and homicide and so on. So that's a big part of it. Kind of opens with the government. The Constitution contemplates that the government is there to provide for the security of the society and public safety. Secondly,
before we move on from that point, because it's very relevant. The case is United States v. Rahimi, right? And we talked about it on the show before, but just to give people a brief overview, this is a case where a Texas man was subject to a domestic violence restraining order. A judge found that he was a specific threat to the mother of his child, that he was accused of committing violence against her previously. And then he was arrested and convicted under federal law for possessing a gun while being subject to that restraining order, which is a felony under federal law. After he had gone on he's accused of going on sort of a shooting spree where he attacked different people at different times, and the police went to his house and searched it, and they found the gun. I believe they found the gun nearby the restraining order. So it's fairly straightforward on that point. He's being, but he wasn't convicted of anything else, and he's currently facing trial for those other shooting incidents. But that's the core of this case, right? The Fifth Circuit said this restraining order isn't within the history and tradition standards set by the Supreme Court, and so it has to be the prohibition has to be tossed out. And so just to give people a quick background on what the case is about. and then go from there. So you're saying
and so
the Constitution says the government has to protect people's right to life.
That's right. Look, there's Rahimi's not one of the good guys, right? And we have to have. Most of us want to live in a society where there's enough public safety that just random people don't get to drive around town shooting at people out of their car window. The second point in the brief is kind of a discussion of human rights law. And this is something that is, it's hard, I think, for non-lawyers to understand its place in our legal system because it's only partly an aspect of American law. It's more the subject of international treaties and some of our traditions with the Nuremberg trials and things like that. But the argument is that human rights law includes an obligation to protect the safety and security of the citizens from violent people in their midst. And so when it comes to that, this kind of like, there's a lot of drawing on reference to international law and the policies in other countries. The argument is not that other countries control what we're doing, but for our country's whole history, courts have at least thought it was relevant to consider what other developed societies and developed legal systems had done with difficult questions of law, like balancing rights versus public safety. And then the third argument, and this is the part of the brief that I was actually most involved with, really argues that Bruen was wrongly decided and Heller was wrongly decided for that matter, that the fact is the Second Amendment was about militias. And I know that the Supreme Court has now said otherwise, but the Supreme Court hasn't convinced most historians of the period. So it's a very prevalent view among people who have really studied the founding era and the background debates regarding the Second Amendment, the things leading up to it, how it was understood at the time, who really think it really actually was about militias and the role of militias, the role of state militias versus a federal standing army, and that it was just a mistake back in Heller for the Supreme Court to decide that there's a constitutional right, individual right to bear arms for personal self-defense. It's not to say that there couldn't be a statutory right or that there wasn't a common law right to do that. The question is whether that's what the Second Amendment was trying to address versus as opposed to militias. And then the last part of the brief kind of argues that even under Heller and Bruen, the statute that's being challenged in Rahimi is still valid and should be upheld.
Yeah, actually, when I got to that part of the brief there at the very end, I thought there was, and we'll get into some of the other parts, but I don't want to get totally sidetracked on, relitigating Heller and Bruen. We will definitely just go through this stuff, but I just more want to give people your perspective so they can understand before we start talking about, analyzing the case and how it might go. But, there was obviously that section where you're describing why you believe Bruen was incorrectly decided and how you believe it hamstrings, governments from protecting people from dangerous individuals with firearms, right? But then it goes right into the part where you argue that Bruen still provides the necessary framework to uphold this restriction on people who are subject to domestic violence restraining orders. How do you square those two things?
Well, two things. First of all, it's very common in appellate briefs for lawyers to argue things in the alternative, to say something like, look, this law is unconstitutional, but even if it is constitutional, it doesn't apply to my client, or to say this case should be overturned. But even if you don't, you could construe the case to allow for what my side wants. And so this is, it's pretty common actually for lawyers in appellate briefs to argue one thing and then say, but even if you don't agree with my main point, I should still win under this other theory. And we didn't develop the last point, the argument that it should still be upheld under even under Bruen, because we know that the government's brief is doing a fantastic job of arguing that, and a lot of other parties or amicus briefs are going to argue that more in depth. And our purpose in writing the brief was to kind of bring up the other issues.
Yeah. So, and I do want to get into that.
Sure.
Sort of the different approach that you took compared to, say, the group like the ACLU, which took more of a middle way approach to this. But first, yeah, let's talk a little bit about Heller and Bruen and why, what your critiques are of it, why you believe it was incorrectly decided, because that is essentially, it seems to me, the main point of this amicus brief.
And I want to say at the outset that we're realistic. We know that that argument is probably not going to win over the conservatives on the court. But there's also, I'm a law professor, and I can tell you that today's dissents become tomorrow's majority opinions. If you look at things in the long term, when Justice Scalia was first on the court, he wrote dissenting opinions and concurrences in case after case after case. And at first the majority ignored him, and then he won over a couple of other members on the court, and others actually started to get pulled in his direction, at least a little bit. And so there is a value in arguing and raising an argument and really articulating it, even if you don't think it's going to be adopted as the majority position in the case today, because it could be in the future. And as you know, people argued for years leading up to Heller that the Second Amendment allows for an individual right. So somebody has to start making that argument at some point before you have 5 votes on the court that agree with you. If I could put it in a nutshell, we have the debates from the people from Congress when they adopted the Second Amendment, when they argued about what the words should be, and made some changes to the verbiage before it was sent to the states for ratification. They spent 2 days debating it and never once mentioned individual gun ownership or personal self-defense. That was all about militias, standing armies, and Quakers and conscientious objectors and pacifists. And so talking about what, Blackstone said or a legal treatise in 1830 said or something like that is all stuff that's worth talking about, but it's also worth talking about what the drafters themselves said when they were haggling over exactly how to phrase it. And for whatever reason, the thing that Justice Thomas now says is the core right that the Second Amendment protects, it's a little weird that it was never once mentioned, even when the Second Amendment was introduced to the floor and open for debate. And I think that that's important, and it's worth revisiting that. And I think in Heller, Justice Scalia kind of just glided right over that and said, well, that's not that helpful and, for us. And I think it's relevant. And I know we're not going to relitigate it. And I don't think we're going to overturn Heller in this case. But even the conservatives on the court should be aware that there are a lot of us out here who still think Heller was wrongly decided. So
sure. And let's just get into that for just a brief moment here. Essentially, you argue that the right is tied to militia service, it seems. From my understanding of what you guys wrote here, you think it is explicitly tied to militia service, that only the people who serve in a militia are guaranteed the right to keep and bear arms. Am I oversimplifying it, or is that how
I think that's not, I wouldn't phrase it like that. I think that there was a lot going on with the militia issues at the time. So one of the other professors who joined the brief, Carl Bogus, has a book out, Madison's Militia, where he really sets forth an extended argument that the militias were slave patrols, and that's why that including the Second Amendment was a concession to the southern states that they would be able to retain their slave patrols. he argues, thought that the militias were actually very effective in wartime in repelling a foreign invasion because they had actually kind of been catastrophic during most of the Revolutionary War. My take about
but there's no.
Go ahead.
Just briefly on that point, because obviously this is it's not the first time that that idea has been raised, and there are counter arguments to it. I mean, I think the most poignant one is that there's no actual quote from a founder or specific reference to this concept that the militia, the Second Amendment is talking about are actually slave patrols, and that the purpose is to
I understand
arm those.
And I'm not going to argue his point in his book, but I do recommend it to your viewers. It's a serious book, and even if people disagree with it, it's a serious book, and he really sets forth a case. I actually think it's more complicated than that. I think that slavery was part of it. I think that there was the first Congress was actually obsessed with how they were going to repay the Revolutionary War debts and finance veterans benefits, and how much they could offload this to the states versus having the federal government do it through taxes. And so there was a heated debate between Hamilton and some of the others about where the money was going to come from to pay for armies and militias and weapons and so forth. And there was an argument for privatizing it. I think that the northern states were focused on Western expansion. So Pennsylvania, New York wanted to go all the way to the Mississippi River. And so they really cared about conquest with the native tribes. And that's historically most of the militia activity in the northern states was actually fighting natives or occasionally suppressing an insurrection like the Paxton Riots or Shays' Rebellion. And then there's the issue of the Quakers. And it's easy for modern people to not understand how big that group was in the founding era and how wealthy and how influential and how politically active they were. So the Quakers followed during the first Congress, they swarmed them. They would follow them in groups down the street. They would do sit-ins in their office. The Quakers did a sit-in in the first Congress, and a lot of it was focused on slavery, but it was also over militias and making sure that they were exempt. And
right, because they were pacifists. Quakers.
They are pacifists. And
in addition to making great oatmeal, they were
exactly. Well, actually, so that they never were responsible for Quaker Oats. That was just a brand name somebody came up with.
Yes.
But they, in the founding era, they had a lot of control over the banking system, almost a virtual monopoly over the whaling and whale oil supplies and the cross-Atlantic
very influential
trade.
Group.
Very, very powerful. And so and they spent most of the time debating about the Second Amendment, arguing about Quakers. And then Quakers come up 2 or 3 other times during the first Congress. And at a couple of occasions, representatives from southern states were actually threatening civil war already over the slavery and abolition issue. And it was a part of the reason the southern states wanted to move the capital out of Philadelphia, because they couldn't stand all the Quakers there and stuff like that. So I think that there was a lot going on there, but I don't think it was just, you have to be in the militia to have a gun. I'm not sure that they were focused on that type of rule. If that makes sense.
Right. I mean, I think that the critique of Scalia and Heller and his view of the operative clause of the Second Amendment versus the prefatory clause, and this idea that the Second Amendment is primarily about protecting self-defense right is an interesting critique, probably a fair one to a certain degree, because if you read the founders at the time, their debate over militias versus the standing army, they, most of them talked about being concerned about standing armies as a tool of tyrants, and they preferred having the people be armed organized in militias that are, competent, so that they could avoid the traditional pitfalls of a standing army that they had, observed throughout throughout the historical record. And, and then at the same time, to me, it just feels as that, you have, Tench Cox, you have even the Pennsylvania's version of the Second Amendment does describe this as an individual right for not just the defense of the state, but the defense of oneself. And so, there certainly is plenty of scholarship that people can look and history that they can examine for this. To me, it does feel like perhaps a distinction without a difference. The idea that the Second Amendment is there to guarantee that militias can be useful in securing a free state, because the militia was made up of the people. Like, the right in the Second Amendment is guaranteed to the people, right? Not to the militia. But I don't know that the founders really saw any difference between the two. And I guess that's what it comes down to for me when I read, your ruling. Even, you guys cite Miller talking about the 1934 Supreme Court case. It was sort of the first Second Amendment case with any ruling to it. And you read that ruling, and yes, they talk about the militia purpose, but they're talking about that in context of saying that everyone was part of the militia, that all the people were part of the militia, and what was protected by the Second Amendment were arms that were useful for militia service. Now, Heller does kind of take a left turn away from that concept, but it preserves the common use standard that was developed in Miller. But you kind of get, in my view, at least, my understanding of things, this idea that the militia and the people really aren't that, really isn't any difference between the two.
And so I understand your point, and I also know we have other topics that you wanted to cover today.
Sure.
Again, this is why
I'll just give you one last. Let you respond, and then we'll move on to the next.
I'm going to go back to the Quakers again and say there was a very large, very well organized, and very wealthy group in the country that would have strenuously objected to the idea that everyone is part of the militia. I mean, they would engage in tax protests, right? Like they would refuse to pay taxes if they thought any part of it was going to be used for the militia. And and in the places where there were a lot of Quakers, like in Pennsylvania during the Revolutionary War, there was an acute shortage of firearms available for the people who weren't Quakers and wanted to fight. So for the Quakers, this was actually an issue at the time, and for the people, James Madison was married to an ex-Quaker, kind of a bitter ex-Quaker, but Dolly Madison was raised as a Quaker. All the founding fathers were very familiar with them, and I think that they were aware that there was a large segment of the population that did not think that the militia was everyone, and that was for them their number one political issue. So
I would certainly agree that there were different perspectives on it.
Yeah, we would both agree on that.
Probably had a different perspective from people like, for instance, George Mason, who also explicitly said that the militia is everyone except for government officials, effectively. And so, that is one thing about looking back at history, especially in a test like Bruen, which I think you guys make another point of, that not everyone in history agreed on all these points either. Right. Now, although I would say that the Quakers were powerful, but they weren't. They were a minority of people at the time too. Right.
That's right.
It's just all right. But so let's so now that we've established the baseline of your point of view, your perspective on this issue and what's in the amicus brief that you filed, I want to get just a little bit about the strategic aspects, right? So you have groups like the ACLU, 97%, I believe, had another similar brief to what the ACLU did, where they took more of a middle road approach, arguing essentially that, they don't say throw out Heller, they don't say throw out Bruen, because like you said, I don't think the court is likely to take those paths.
Right.
But they do say, the ACLU's brief in particular, I think is fascinating because they talk a lot about the idea that what the government wants to do in this case is overly broad, that the power they're trying to assert they have is too vague, and that and that additionally some gun laws, some other of the prohibited persons sections in federal law might actually be unconstitutional as well. But they have a solution where the court can still uphold this regulation at play, right? This domestic violence restraining order gun ban, but through a more narrow approach that relies on a dangerousness standard of, whether a judge has determined somebody is a danger to another individual or society at large, as sort of the baseline. But I don't want to get bogged down in the specific standard that they're proposing. They're just proposing a sort of third way option here. How do you think the court is going to actually come out? Do you think that's going to be convincing?
So I think that if you just talk about the conservative bloc on the court, that I think they have overlapping but varied views about gun rights and what regulations are permissible and how the Second Amendment should be applied. And it's clear from, if you read all the concurring opinions in Bruen, that they said, I'm signing, but I think this, and then kind of disagree with some of what the majority opinion says. And so I do want to say up front that anyone who thinks they know for sure what's going to happen in Rahimi must have fortune telling powers, because the fact is that we're not exactly sure where all of the different conservative justices are going to come down. And part of the value of a brief like what you're describing, the ACLU's brief, is that they're saying, look, they're concerned about wanting to protect the rights of domestic violence victims, and saying, well, it's okay to disarm people if a court has found that they pose a danger. Now, don't get your hopes up if the court is going to grant a restraining order, a domestic violence restraining order against you. They're probably also finding that it's because you're dangerous, that you pose a danger. And so, but it's their way to, one thing you can do strategically when you're a lawyer arguing on appeal is try to win your case on very narrow grounds, right? Say, look, we're just asking for a baby step here. All we want you to do is protect people in this type of situation, or save the law for this type of situation. And we can revisit all the other cases another day. And there's a lot of judges, if they're justices and appellate courts, that if someone's on the fence about what to do, that's an appealing, I don't want to call it a compromise, but it allows them to not buy the whole farm right now, if that makes sense, to say, okay, we're only deciding this very small point today. And to be honest, that's what Alito, his concurrence in Bruen, said, is that that's what he thought he was doing, was only deciding that the New York permitting system gave a little too much discretion to the local law enforcement without safeguards. And so that type of argument could win someone over who feels conflicted, for example, on the court about what to do in this case. Yeah,
and I'm interested in where like you said, there's no way to predict this. It's just reading tea leaves. We have Bruen, and we have the concurrences that were written in Bruen, and certainly the Kavanaugh Roberts concurrence, and even the Barrett concurrence give you some question as to how far they're willing to go in striking down gun laws. And I think that actually the government's brief in particular made a really good practical argument. There's a lot of focus on the historical aspect and obviously because that's what Bruen requires, but it's easy, I think, to look at what the Bruen test is and then forget about the reality of the Supreme Court and how these things tend to work in practice,
right?
Because some of those things, that some of the critiques of Heller that we sort of went over earlier, I think it's fair to say that a lot of that stuff that made it in there, like, focusing more on self-defense rather than, usefulness in battle of firearms, which is what Miller had done, probably came from Kennedy, because he didn't.
Right.
They were trying to get 5 justices on board. That's always the struggle. And so they're trying some of these things. I think Heller is in a lot of ways a compromise ruling in that regard, and that leads to some of the issues that we've discussed. But so the government does a good job of pointing out that this particular law is very popular in terms of how frequently it's been adopted among the states. Heller, the handgun ban, really, there are only 2 places that had that at that point in time, DC and Chicago. Right. And then in Bruen, there are only like 8 states that had that, the law in question. Whereas you get to domestic violence restraining order gun bans, and the government at least claims there's 48 states that have that, which I think is some similar law to that. And, the court might not be willing to actually go that far and be that disruptive. I don't know. What's your feeling on that?
I think it's probable that they're going to uphold the federal law in Rahimi. How they do it, or how narrow they do it, or what, whether they really backpedal from Bruen, or maybe they're just is hard to say. I agree with you that. So, for example, I tell my law students, essentially Roberts is now the swing vote. Roberts and Kavanaugh are sort of, at this point, sort of the conservatives on the court most likely to vote with the liberals. And so it's hard. And I think they signaled in their concurrence that they weren't really wanting to mess with 922G with any of the sections. That's what I understood. And I'm not sure, based on what some of Alito's concurrences and dissents in previous gun cases, like the one about unlawful immigrants, that he really would want to get rid of a law like this. And so and there's something to be said for a law that's popular among the states. Like you said, Heller was a challenge to an obscure law, a really drastic law. But we have a phrase that the Supreme Court likes to use. They talk about the states as laboratories of democracy. And they've used the phrase for about 100 years. And so, at least for some people on the court, they give some weight to the fact that a lot of state legislatures have wrestled with the policy issues behind this law and actually want something like this. And that matters, as opposed to one state kind of going rogue or being a maverick or having a quirky rule. It signals that there's a consensus, and so the rule isn't completely crazy, if that makes sense.
Yeah, I think it does make sense. And you can even see that in Bruen, because at points they're talking about how, the historical laws, they didn't give as much weight to those that weren't adopted by, a large group of states at the time, because they don't cover as many people. They're not necessarily considering that to be part of the tradition. I know there's a whole critique on that point too. We don't need to get into, but it does seem in line with their thinking on these matters. So It'd be interesting to see how they go. Of course, at the same time, we know the goal in your brief was that you want to see all this jurisprudence overturned and gone, but eventually, I do wonder. Right, eventually.
Eventually.
Like you talked about, you're not expecting that to happen.
This is the long game. Yeah.
Mm-hmm. And so I guess my question would be, it's only been a year since Heller. I mean, since
Bruen, right?
Since Bruen, it's been much longer since Heller, but it's only been a year since Bruen. How much do you expect them to really rework that, even with what's unfolded in the lower courts?
So there's a couple ways that they could backpedal from Bruen in baby steps, right? That they could. So one is to basically adopt Roberts and Kavanaugh's concurrence as what Bruen really means. It would not be this first time the Supreme Court has done something like that. Back in the Warren Court era, we like to talk about Justice Harlan's concurrence in the Katz case. So there have been times historically where one of the concurring opinions really took on a life of its own and became the rule that the court followed instead of the original majority opinion. And that I won't be surprised if that happens. The other thing that they could do that would be a minor tweak to Bruen instead of just throwing it all out would be a very subtle burden shifting. Right. And so instead of saying the government has the burden to show that there's historical analogs, to shift the burden to the person challenging the law, that they actually have to show that there wasn't. And so that's an aspect of Bruen that hasn't been talked about a lot, is it shifted the burden to the government in a way that we usually don't do in constitutional cases. So normally there's a presumption, the courts have a strong presumption that laws that are passed by Congress are constitutional. And so the burden is almost always on the person challenging the constitutionality of a law to prove that it's not. And Bruen is weird in that it seems to say we're just presuming any law that relates to guns is unconstitutional unless the government can convince us otherwise. And that's an outlier, or kind of a weird going off the path for constitutional law in general. So I won't be surprised if their sort of way to not get rid of Bruen, but backpedal it, is just to shift who has the burden, at least initially, in these cases.
Interesting. I think that would represent a huge reversal in my mind, at least.
Yeah, I understand it has a lot of implications, but it's kind of a subtle change, and it doesn't guarantee that a gun rights group can't win. Right? A lot of times, both sides are still going to make the same arguments. It's just the question of who has to prove their case, as opposed. But the fact is, both sides have been trying to prove their case in all these cases up till now. So. Yeah.
That's a fair point. I'd be surprised if they went that far, but
we'll see.
I mean, I'd be less surprised if they, adopted that sort of ACLU middle ground of, we're going to look at this from a broader perspective because, attitudes on domestic violence have changed so much, and even guns have progressed in their technology over, the last 200 plus years. And so we're going to take a little bit broader view of what's analogous in this case and go with this dangerousness standard. That would be something I could see them doing as like a sort of a middle ground. I mean, they do need to clarify a lot of this stuff. I think that's undoubtable. And how do you actually, what counts as a proper analogy? There's still a lot there.
And if I could put this in just a little bit of larger context with the Fifth Circuit versus the Supreme Court. The Fifth Circuit right now is very conservative, and in the last couple of years has put out a bunch of kind of stridently conservative opinions that represented a big break from prior precedent in a lot of areas of law, regulatory law especially. And to be honest, they haven't been faring that well with the Supreme Court, even though there's a conservative supermajority. The last term, if you're like ranking which circuit got upheld the most, the Fifth Circuit was near the bottom of the list in terms of how often they got reversed by the U.S. Supreme Court. So it is important to keep in mind that we have a Fifth Circuit that is not in lockstep with the current conservative majority on the court.
That's interesting. And of course, at the same time, I could also see them not being willing to do that sort of broadening that I just spoke about, and taking the Fifth Circuit's view of this, especially because restraining orders are a different level of due process than criminal convictions. And so, like you said at the beginning of this, it's we can't know. It's impossible. I think it's
can't.
good to have these conversations.
We can't.
With people who understand what's going on, but it's not possible to know.
And I do want to say something, if we have a moment, just about what you just said
Sure.
about due process, if I could talk about that. It's really not fair to say that there's no due process. I see a lot of, posts from gun rights groups and stuff saying that there's no due process in these cases. I really don't think that's true. It is true that a lot of restraining orders can be ex parte, where one party goes to a judge, but you still have to convince a judge. And to be honest, most judges, really the vast majority of judges, are going to try to do the right thing and try to be fair. And the other party, even if they weren't there for the initial hearing, has procedures and plenty of process to challenge a restraining order if they think that it was based on a false premises or they've been wrongly accused. And I understand that there's a range of views and reasonable minds differ about how much due process we have with restraining orders and temporary injunctions and things like that right now. But it's really not accurate to say that there's no due process. It's the question is, how much process are you due? Right. And so
I agree with that.
Enough? Yeah.
I agree with that. There certainly are due process protections. And in fact, in Rahimi's case, I mean, there was some details about whether I don't think the actual hearing happened, but he agreed to waive the hearings. That's why I didn't.
That's why
there's some more detail to that. I just think that on the general point is that there are less due process protections for restraining orders than there are for criminal convictions. That's all I mean. And so I don't know if the court will find that to be, too much of a problem like the Fifth Circuit did, or if they will say, well, you get at least some due process protections here. It's not, totally, absent from the situation. So we'll see though, like I said, I think I could see it going either way. I lean more towards the sort of ACLU middle ground that the court might come, because I just think that practical argument about how many how popular this particular restriction is makes sense, and that ACLU middle ground gives them a way to do it without massively, expanding the power of that expanding is the wrong word, but without giving the government a really large leeway, a lot of leeway on their power to restrict firearms. So I don't know, but we'll see. And I really appreciate you coming on to give us your point of view, because we like to have as many different points of view as we can on this podcast.
I appreciate you having me.
So where can people find more of your work if they'd like to do that?
Most of my articles about gun violence and gun control are available on ssrn.com. If you search on that for my name, and they're available in the law reviews and academic journals where they've been published. So
okay, wonderful. Yeah. And perhaps we'll have you on again in the future to talk more about these issues. Maybe we'll dive more deeply into the historical relitigating of Bruen and Heller at some point. Maybe people will be interested in hearing more.
It doesn't hurt to talk about it. So,
no, it certainly doesn't. And maybe we could have somebody who's more your equal in that regard, and another law professor on the other side of the issue, or historian, or what have you. But I appreciate you coming on, and we're going to head on over to our news update now.
Okay, thank you.
All right, ladies and gentlemen, it's time for the news update. I'm contributing writer Jake Fogelman, joined, of course, by Reload founder Stephen Gutowski. How you doing this week, Steve?
I'm doing pretty good. I'm about to head on vacation here. You're sort of the kind of vacation that you take when you run a business yourself, which is like a short 3-day weekend vacation. But we're going to, me and my girlfriend are going to Assateague Island, which is where they have the wild horses.
Oh, nice.
On the Maryland coast there. So that should be a lot of fun. I think Jake Tapper's first book takes place on this island too. There's communist spies. So hopefully
you don't run into those.
Yeah. We'll see. I don't have a Maryland concealed carry permit yet, so I don't want to run into any communist spies at this moment. But hopefully we'll run into some wild horses. That'll be fun. Not run into them literally. I don't want to get too close to them, but they are very beautiful.
No, that's cool. Yeah, I didn't realize there was wild horse populations out on the eastern seaboard like that. So that's really cool. Hopefully you guys have fun.
Yeah, they're right on the shore. It's pretty cool. So you get to do the beach and the horses. So it should be good. And I think it's going to be nice weather. It's a little bit later in the summer here, so hopefully we won't be sweating too bad, and we can enjoy the ocean and all the nature out there and on Aztec Island. I'm looking forward to it. What about you? What are you up to?
Just getting ready for football season. I just had my fantasy football draft in one of my leagues. So it's been a long summer without football. I'm not really much of a baseball fan, so I've kind of been without my favorite sports. So I'm excited to see that going. I've been conscientiously avoiding preseason football. We kind of talked before we started recording about how brutal preseason football can be.
Yes.
So
yeah, I watched the Eagles preseason game last night, the third one, the last one. And which is really the worst one to watch, because that's when nobody of any real potential of being a regular starter is actually playing in the game. There was actually a super embarrassing moment for the Colts new quarterback. What's his name? Robinson, I think. He's a Florida State guy. He drove down the field and he scored to tie the game in the first quarter, and he did the Eagle wave thing to mock the Eagles. And I was like, it's a preseason game. What are you doing? This is embarrassing. And he had a terrible game too. I think he had like a 50% completion rating in the preseason against not even our backups, our like third and fourth line guys.
The scout team guys.
So man, I don't think I've seen something that embarrassing in football in a long time, frankly. But ever since that, maybe the last play that the Cowboys ran last season, where they had Zeke as the center and just immediately failed. If you remember that, It was almost that embarrassing. Of course, this was preseason and not the playoffs, so it wasn't quite the same level. But either way, it's hard to watch those games.
Yeah,
you just kind of go on YouTube and watch the video breakdowns of players that actually are going to have potential of making an impact. So I don't have to try to watch the game and see if I can spot them during the live broadcast. But my fantasy draft is tonight, actually. So looking forward to that. My first one. I don't know how many leagues I'm even in at this point. Too many. But my friend group league, we're doing our draft tonight. So we're driving out to the beach and doing the draft. So we're going to be in this beautiful area, and I'm on a computer for, I don't know how long draft takes, an hour or more.
Yeah.
So hopefully it'll be worth it. Hopefully I can get a decent running back to start out. I hope I'm high enough in the draft to make that happen. We'll see. Anyway, what do we got in terms of news of the week? What headlines we have?
Yeah. So to the newsletter, we got a pretty interesting report from the Wall Street Journal. They took a look at ATF revocations of federal firearms licensees. It's been a concerted policy by the Biden administration to do zero tolerance on what they perceive as violations by federal firearms licensed dealers. And they found a substantial increase in the number of revocations. So as of this fiscal year, there's been 127 revocations. That's up from 90 last year, and that's up from 22 in 2021 when that zero tolerance policy was first announced. So it's been like a quintupling in the last 2 years. So definitely an increase.
Yeah, and the gun industry has complained that they're revoking licenses over minor paperwork infractions. Basically, that's been the complaint, that they're intentionally trying to find minor things and revoke people's licenses and basically put them out of business for over that. And this has obviously been something that's been a priority for the gun control movement for a long time. They've complained for years about ATF, and they've claimed there's lax enforcement and they don't revoke enough licenses. And so this is certainly Biden once again trying to use the tools that he has in the executive branch to make the gun control movement happy. Because he can't get legislation through like he wants, and so these are the things he can do, and he's definitely pursuing them full steam. Yeah, for sure.
Yeah, and there's all sorts of interesting details in that story from a couple gun dealers that were interviewed, and then some former agency folks that are questioning the strategy because they say that gun stores have been reliable partners in cracking down on gun trafficking and that sorts of things. So readers should go ahead and check out that story. It's a pretty good report. The next piece we got is from the Washington Post, where they took a look at DC's red flag law, which was passed in 2018. And they found out that a lot like other blue jurisdictions with a lot of gun control laws, that their red flag law rather is pretty rarely used. I think it's only been used something like 50 times in the last 5 years. And we kind of see that all over the place. We see that in places like New York and California. So it's just interesting that yet another sort of gun control hotspot, you're not really seeing much use of red flag laws.
Yeah. And, the thing with red flag laws, even if you support them, obviously there's a lot of controversy over these, especially in the gun rights side of the aisle. But even if you support them, I think advocates often will blame this situation on sort of lack of understanding, lack of knowledge among the general public about what these are and how they actually work. And so if you don't have people requesting them, they don't get issued. Although I will say, the framing of this story from the Post is interesting to me and sort of plays into a lot of those concerns that I think critics have of these types of laws, which is essentially the story. The headline is DC's red flag gun seizures are low. Officials hope to change that. And it's like, well, low, low compared to what is the standard we're using here for low? I mean, obviously, 50 in 5 years, it's not a lot of them, but do we know that that's what is the number that the Post seems to be looking for? And why is the end goal to just get the number up, right? That just seems like we're looking to fill quotas, which is not what these laws are supposed to be about. They're supposed to be from an advocate's point of view about, helping people in a mental health crisis, not about reaching some specific number of red flag orders issued. So I thought that was kind of a terrible way to frame the story.
Sure. Like you said, it kind of indicates some of the fears of folks that are skeptical of these laws. But the last link we'll hit today is from Politico, which they touch on a pretty interesting dynamic in the Indianapolis mayor's race. So they have a Republican candidate there who's trying to unseat a Democratic incumbent, and he is adopting a whole host of gun control laws. Apparently, he supports an assault weapons ban. He wants to repeal permitless carry within the city limits of Indianapolis. And I think he wants to raise the age to purchase a firearm to 21 as well. So it's just sort of a unique thing to see a Republican come out and support gun bans, for example. I think Politico gets a little, over their skis about how this could, potentially signal that the Republican Party writ large is shifting on guns. And I'm not so sure about that. I think it's more of specific dynamics of this race, but it's interesting nevertheless.
Yeah, I mean, I wouldn't take a mayoral race in a large city as evidence of how the Republican Party writ large is going to pursue things going forward. But I think it's interesting to look at because you don't see that much effort put into winning races in areas that either party is not very strong in. So that's interesting to me to see. I guess we'll have to see how well this guy actually performs. Right. And how, whether he's funded by the party and whether there's like a significant structural push to get him elected in Indiana. But it could certainly foretell a sort of reversion back to where the parties actually try to compete in areas that they aren't completely 100% locked down. You know what I mean? Like, maybe you'll see more urban Republicans who try to moderate on the issue. I think it's probably not the most sophisticated method of moderating on the issue because it just sounds like he's just kind of aping what the Democrat in the race is going to be running on when it comes to guns. And so you would think they'd maybe try to find some way to contrast. I think there's plenty of people in urban areas who aren't necessarily desiring total gun bans as the solution to their that they want to see. I'm sure that there's plenty of maybe licensing reform stuff for concealed carry or even handgun ownership in a lot of these states. I mean, Indianapolis is in a red state in Indiana, so that they may not have the same sort of onerous restrictions. But regardless, you could moderate on the issue while still offering a contrast, I guess is what I'm trying to say. And I don't know if that's what this guy's doing, but in the end, I'll be interested to see if you get more Republicans going into deep blue city areas, urban areas, to try and be competitive there by, moderating or changing their position from the party on certain issues like guns, and vice versa for Democrats. Oh, I apologize. You got to clear my throat here. I'd be interested to see if Democrats do the same thing, trying to go in more rural areas and take more pro-gun positions, because you haven't really seen that in either party in recent decades, really, the last decade or so. Things have become really polarized. And, if this guy wins, or if you see more of this on either side, perhaps that'll signal maybe a lessening of the partisanship we've really gotten into, the sort of partisan stalemate over the last several years. So that's what interests me most about this. I don't think it foretells the Republican Party becoming, pro-gun control, but it could signal more of these attempts to have the parties cross over into areas where they haven't been competing of late.
Yeah, no, I think that's a good point. And like you said, it used to be the norm, so it would be interesting to see if we go back to that. But now I guess we'll turn to some of the stories we wrote this week. We're starting with an interesting ruling out of Massachusetts. This was actually a criminal case, but what the judge found in this case, it was a New Hampshire man that was charged with illegal possession of a firearm in public in Massachusetts, because I guess he was traveling through the state and he got caught. The details were pretty scant in the ruling, but the judge,
I think he had a couple charges, right?
Yeah, I think it was a separate. It looked like it was a separate case.
Several separate ones.
Yeah, something about being like intoxicated while operating. So I'm assuming like a DUI or something like that.
Yeah, it kind of sounds like he got pulled over for a DUI, and then they found a gun in his car, and so they charged him with gun possession without a license and carrying without a license in Massachusetts. Yeah, he's not from Massachusetts. Right.
And what was interesting is the judge in that case actually tossed those charges and said that Massachusetts requirement that out-of-staters, so non-residents, get a permit before they can carry in public is actually unconstitutional. So that's one of the first rulings that I've seen dealing with the rights of public carry across state lines. So potentially big.
Yeah, absolutely. It could be huge if this is something that catches on. Obviously we're talking about a state judge in Massachusetts, so the immediate impact is fairly limited. We'd expect that the attorney general there is going to appeal this case. We haven't heard from them. He reached out, but they didn't respond. So we'll see how long this ruling stands, but it is done under the Bruen standard. So it could certainly be influential as other judges address the same issue under that same standard. You could see the spread. And national reciprocity, where permits from each state are recognized in every other state, sort of like a marriage license or some other, a lot of other licenses. If the gun rights movement has wanted for years now, the top priority has been national reciprocity, where all states recognize all other states' permits, and this would be a step to that. If it takes hold and more judges come to the same conclusion under the Bruen standard.
Yeah, no, you're right. Every time that, well, even when they're not in control, but especially when Republicans control Congress, you always see a national reciprocity bill introduced. Like you said, it's a long time goal for gun rights advocates. And, some even thought that perhaps the Supreme Court would establish it in one of their carry rulings. We haven't seen that yet. But you're right. If this argument takes hold and more judges find that the Bruen analysis does in fact support that, perhaps we'll see national reciprocity through judicial means down the road. But we'll turn to our last story of the day. Is a story you wrote actually about the Republican primary debate. So the 8 candidates that qualified had their first televised debate last week, and were kind of left a lot to be desired on the subject of guns and gun policy and the Second Amendment. If you want to tell us what you saw in that debate.
Yeah, obviously the main discussion of what was missing from the first Republican debate was that Donald Trump wasn't there, and he's the front runner and former president, and who's obviously currently facing a bunch of federal charges, but he decided to skip the debate, and then he sort of tried to undercut it both by doing an interview that aired at the same time with the former Fox News host Tucker Carlson, or aired, I guess it was posted to Twitter at the same time. And then also by turning himself in the next day and having his mugshot be released. So he's kind of, attempting to take attention away from this debate with the other candidates. And in addition to his absence, you had the absence of gun policy. Nobody talked much about this. The only thing you got, and it's interesting too, because Fox asked,
right.
Brett Baier asked specifically about gun policy and what the candidates would do. He asked Chris Christie that first, and Christie was the only one who had any sort of gun policy aspect to his answer, which was that he was criticizing the way that President Biden's Justice Department has handled the Hunter Biden charge over possession of a gun while being a drug user. He claimed, now this is not actually correct, but he claimed that Biden instituted a mandatory minimum of 10 years for that crime. And then, of course, that's not the mandatory minimum. That is the statutory maximum, which is almost never actually given out for this particular charge. But regardless, he did have a point about as well about sort of the hypocrisy of Hunter Biden not being pursued aggressively on this point, despite President Biden's staunch advocacy for stricter gun laws, right? And so that was basically the only comment of the night that had anything to do with gun policy. The rest were talking mainly about crime, and essentially they kind of all had a very similar position of more police and tougher prosecutors. And, there were some differences. Christie said that he would make federal prosecutors do more violent crime prosecutions in cities where they had weaker prosecutors. DeSantis said he would remove weak prosecutors like he's done in, or what he views as weak prosecutors, as he's done in Florida. There was really just no talk at all about the Second Amendment beyond that, which is kind of surprising. You'd think that these candidates would, one, want to differentiate themselves from the other candidates on stage. And some of them have even, DeSantis in particular, has kind of gone out of his way in the lead up to his campaign to get a bunch of credentials on this issue, to sign a bunch of gun reforms, pro-gun reforms, right? He signed permitless carry. He signed the bill that bars financial institutions from dropping business with gun companies, for the sole purpose of the fact that they are gun companies, right? And so he'd done a lot of work on this issue, and he didn't tout it at all. I think Asa Hutchinson also signed permitless carry when he was governor of Arkansas. So some of these guys could have said something, right?
Right.
Ramaswamy has come out in favor of legalizing machine guns, which would certainly differentiate him from most of the other candidates on stage. And then they just didn't talk about it. And neither did President Trump in his interview with Tucker Carlson. Didn't bring it up. Talked about low water pressure for I think probably about 5 minutes. I watched that part. He's talked about that a lot in the past too. It's sort of one of his pet issues, interestingly enough. But he didn't talk about gun policy, and that was the other way they could have differentiated themselves from the front runner, Donald Trump, because he's got some vulnerabilities on this issue from the right. He instituted the bump stock ban unilaterally. It's been found unconstitutional since then. He made a bunch of comments supportive of different gun control proposals, take the guns first, due process second. There's definitely areas where these candidates could draw a contrast, and nobody did.
Yeah, no, especially I think the point is, it's one thing, it's a first debate. There's a lot of topics you have to hit.
Yeah.
It's one thing if you don't touch guns, but to your point, Brett Baier specifically posed the question, we've seen a lot of shootings in Milwaukee, for example, which is where the debate took place. Democrats blame that on access to guns, and they say Republicans don't support gun control. What do you think about that?
Right.
And not one candidate took the opportunity, in a Republican primary with a primary electorate to say, I stand firm in support of the Second Amendment, or, whatever they might say.
I don't believe the Second Amendment was even mentioned once.
Not once.
Nobody said the words Second Amendment. So I was pretty surprised by that. We'll have to take a look at the, maybe the polling and what we're seeing, like if there's some trend that they're all taking note of, or if this is just a pure missed opportunity for most of them, and a lot of these guys aren't necessarily going to make it to a second debate, right? Like the rules tighten after this one. Yep. And so, maybe it'll get addressed more directly in the next debate. I would hope so, right? I mean, Republican primary voters, I think, are very interested in this issue and want to know what policies these guys support, and want to hear them talk about it and gauge whether they're genuine or not. So I would hope that we get that at some point. And it's just kind of surprising not to see anyone try to differentiate on that specific issue in this particular debate. But that's all we've got for this week. If you want to read more about all these things, you can head over to reload.com. You can sign up for our free weekly newsletter, which we send out, as the name implies, once a week. We don't flood you with a bunch of emails. And if you want to support this reporting and also get access to our analysis pieces that are reserved for members, you should buy yourself a membership. You will also get this podcast a day early and the opportunity to appear on the show and participate in our Q&As when we do those. We just did one last week if you want to check that out. It's something that lets us keep the lights on here, lets us do this reporting and bring it to you. So, please consider buying a membership today if you can. And if not, please consider liking, reviewing this podcast, sharing it with your friends and family who might be interested, and perhaps giving us a thumbs up on YouTube where you can watch these to see our beautiful faces while we talk. But that's all we've got, and we will see you guys again real soon.